Of the Corporate Lawyers Association. Well, like every endeavor, we begin with something small, and there is a very little group of people here with us now, but I'm sure it's the beginning of further greater things. Now the floor goes to Anton Ivanov. As I understand, we've all participated each in different roundtable sessions, so concluding the day, as I understand, is about giving your assessment of the roundtable or session where you participated and sharing your opinion on what was so useful about it for everybody, including those who did not participate, so that next year they might feel inspired to attend an event like this. The roundtable I attended was actually quite relevant because in the Duma, as well as in the research and scientific community, they are continuously discussing a possibility of passing the remaining outstanding parts of the civil code, in particular the one of...
Во время этого форума довольно бурной дискуссии по поводу соответствующих ограниченных вечных прав и
property law, and it's precisely about the property rights and the conflicts with the rental and lease claims. Now, in fact, those who represented the property law were not there at this discussion, so we decided to keep the lease and the rental rates, as well as to keep in a restricted version the property rates. So basically we tried to make everyone happy, and the representatives of the business said that for them what is important is that the modified civil legislation then corresponds to the public law, and they see the major issue in that the public law that's poorly elaborated and oftentimes are in conflict with the ideas stipulated by the civil code. The civil law experts agreed to this and proposed a number of organizational solutions that might encourage the coordination of the norms of public and private law. Now, considering also the presentations by a German guests who shared with us their experience and how they brought in line the legislation in Eastern and Western Germany, in particular regarding the land and property rights. This was very illuminating, and we realized we could not do without this when we bring together the rights to property and to the land under this property and passing it into one pair of hands.
Антон Александрович, добрый день, большое спасибо. В очередной раз хотел бы задать вопрос. А нельзя ли Гражданский кодекс оставить в покое?
Good afternoon. My question is, can we leave the civil code in peace? Yet again, I'm sorry for this, and I'm convinced that many who are practitioners of law, as well as theoreticians, I believe many would agree that in the body of the Russian legislation there are not that many adequate, harmonious laws, and in fact the wish to amend things is quite easy to understand, but the best counters what already is good enough, and also we are not exactly in the situation East Germany was in in its time. I understand I'm asking this question perhaps at too late a stage, but it's better later than never. So can we leave it in peace? I am ready to take this question. In fact, I personally believe that without touching upon other sections of law, we can do it, because with regard to the property law, there is no way we can bypass it, because we'll have to change things, because the land code of 2001 that introduced significant amendments to the property rights as stipulated by the civil code has a number of bombs that are still taking in it. In the first place, the duty to re-register certain property rates, the rate of termless usage of property and lifelong right to inherit the property. This gets revisited once every year or once every 2 years, but at some point of time we'll have to address that. What do you do about those who have not re-registered their rights? I mean, you cannot deprive them of their rights to property, to land, to the residential property, or shall we grant them with specific property rights? The developers of the property law believe that these rights should be given to these people. These rights should not be taken away from them. I'm not touching upon other parts of the code, but regarding the property law, I believe that is really the only way forward. If I may, a comment from business lawyers. Thank you very much for agreeing to keep the rental rates the way it is. But we're very concerned about the following. You see, the classical civil law and the basics of the Roman law, the rental is not a property law, but the right to inherit the rental contracts is a whole different story. Well, I don't know what steps the Duma is going to take, but formally the developers agree to that both should be preserved. Thank you very much. I know you're rushed. Thanks very much for participating in this. A round of applause. A few words about your colleagues. Well, I'll immediately answer your question. No, we cannot live in peace. Federal law number 44 and 223, because our discussions has just demonstrated that both laws, especially law number 223, really have to be amended. There are quite a lot of people who want to leave them in peace, and particularly it's our administrators of budget and the owners of the federal unitary enterprises, the enterprises with a stake belonging to the government, however, not all of them, because the understanding of that we really ought to save the funds, both the public and the quasi-public funds, is really there.
Because we have been a WTO member for 3 years already, we still maintain this mechanism of supporting domestic manufacturers. But we don't have such a priority. We cannot give priority to government companies, priority in terms of access to procurement, but we have other legal instruments, other legal tools. We had a very open dialogue, open discussion. We had Andrei Tsirikovsky speaking. You know that he is deputy head of the Federal Antitrust Service. He gave us an overview of the antitrust service, law enforcement practice, the kinds of complaints filed by people. And even though we keep trying to improve that area, including Law 44, the number of complaints has been increasing year on year, and you have to respond to them. You know that this bill was adopted in the first reading by the Federal Duma last winter. Now we are waiting for the amendments and for the second reading to change some things. Some of them, because the fundamental principles would be to getting away from Law 44 by way of bringing subsidies to the targets, unitary enterprises and municipal unitary enterprises. The amendments to that effect have been introduced into the bill. It was identified that during the tenders, the focus is made on subjective criteria rather than objective. In other words, the criteria to meet make it very clear who the winner should be. They are custom-made, so to say. There's a frivolous requirement vis-a-vis funding in the construction area. You know that it's capital intensive area. There's a lot of government money spent on construction, and the procurement is moved away, and tenders are moved away from the electronic platforms to the procurement platform. Many said that the number of e-venues, e-tender platforms should increase. You know, there's ongoing debate whether you want to have just one platform or a lot of it, because when you have a lot of it, there's lots of abuses. But if there's more positive things than negative things with respect to 44, as for Law 233, we all agree that it's a framework law. It did not change the procurement situation. Lots of problems, and one problem is that my iPad battery is dead, and I have to get to my iPhone to see what the notes I was taking. I hope it works. So everyone, all panelists, including the panelist from the Federal Antitrust Service, all agreed that the law has to be changed dramatically. The amendments are ready; they are being discussed but not submitted to the to the Duma. The proposals include the development of a single approach to procurement and a single form, because it's now a tender may be anything. Criteria may be taken from the ceiling, or you may write a tender in a way where the bids do not mean anything. Or, you know, the tender management, if the winning company is not what they want, they can declare the tender void and have a new one. You know that you may have a tender where one participant is responsible for the documents, and if they are responsible for the tender documents, they have better chances to win than anyone else. Also, even though there is a special preference given by law to small businesses, win tenders very, very seldom. E-tenders are discussed, and there is a proposal to harshen penalties for violations of 223. Some of the ideas were to incorporate requirements under 44 into 223 and to remove broad interpretation for those who organize procurement for government-owned companies. Well, a lot of major government companies now realize that the procurement system must be as transparent as possible, and it has to do with the import replacement policy, what President talked about. That's why the railways and the nuclear ministry and Gazprom and Rosneft and Rosatom are beginning to buy domestic products. Our pipe makers and metallurgists all agree with that, but still there's lots of problems. They may be resolved by way of making the requirements uniform. And the antitrust service, as the main drafter behind the amendments, will help us make the procurement system in Russia even more transparent. Applause, please. Thank you, Victor. Let's acknowledge our panelists. Thank you very much. And now I'd like to give the floor to who, Sergey? You? Let me give the floor to Sergey Pozarevsky, head of the legal department with the Federal Antitrust Service. Thank you, Alexandra. Thank you very much. I would like to introduce the round table on antitrust legislation in contemporary economic conditions. The participants represent antitrust authorities of Russia, foreign countries, Eurasian Economic Union experts whose job is to assess antitrust situation in Russia and internationally. Now let me report some major conclusions of my group to the distinguished audience. The purpose of the roundtable discussion was to identify antitrust regulation parameters in contemporary economics, to find some kind of golden medium where antitrust regulation will contribute to economic growth and economic development. In the course of the discussion, we covered different antitrust regulation models, approaches to the balance between public and private interess, possibility to restrict entrepreneurial initiative, and that is what antitrust regulation does. The regulation is based on mandatory requirements, and that will be the case while it contributes to Russia's economic development and other countries' economic development. As a result, we came to the conclusion that without a system of efficient antitrust tools, it is impossible to secure freedom of economic activities. The economic freedom, which is guaranteed by the Russian constitution, has certain limits. And the limits are set by antitrust requirements. A company with a big market share on the commodity market, if this company has more economic freedom than its counterparties, that freedom will infringe on the interests of her counterparties, and then the antitrust legislation steps in and restores the economic balance. And then, in its turn, will help secure the equality proclaimed by the Constitution and economic legislation. Then, those counterparties will become equal players, equal economic players. Another subject which we discussed was the relationship between antitrust regulation and IPR regulation. And that is the subject which has been discussed for more than 1 year. And the solution has not been found. Still, the issues defined by the antitrust service show that there's lots of examples where private interest of right holders result in violation of public interest and competition restriction. All markets, all developed markets have limitations for IPR holders' rights, where the rights conflict with the rights of competitors and the general public or the government. In our country, antitrust tools cannot apply against the rights of against the holders of intellectual property rights, and that can hardly be justified. So the discussion resulted in the proposals to look for the best possible balance between IPR holders and other sectors of economy to prevent a situation where the rights of IPR holders limit or restrict the interests of other players. The subject requires more thinking. Of course, we have not identified legal tools, but we have identified a vector to follow. Another subject was reality. We have existed in for a long time, especially since the 1st of January 2015. That's the Eurasian Economic Union and a single economic space covering Russia, Belarus, Kazakhstan, Armenia, and in the very near future, Kyrgyzia. The single economic space without a single set of antitrust rules is unthinkable. And if antitrust standards are different in different countries, we'll never have a single economic space. Therefore, when we discussed those issues, we had a presentation done by Sergei Maximov, head of the EU Commission. Let me emphasize that we have delegated our national powers to the supranational level. The supranational body will take decisions about what has to be done about antitrust violations in a single economic space, single economic Eurasian Economic Union. We haven't had specific cases, but the legislation and procedures are all ready. That's why in the very near future we'll see how antitrust regulations work in the Eurasian economic space. Judicial practice was discussed. We came to the conclusion that even though traditionally we are part of the continental legal system, still the precedent has great significance, and we demonstrated that using specific examples. We all agree that the efficiency of judicial application of antitrust rules impacts on antitrust policy. So it was not a full stop, it was a comma. And we promised at this special Jubilee Forum, because the forum is 5 years old today, next year, we promised to report the results. Thank you. Thank you very much. Thank you very, very much, Ruslan. Anyone else willing to share your impressions? I may. Go ahead then. Our facilitators have run out. We still have one surviving facilitator, but it would be great if you could have the floor. Would like to try this new format. What is better, whether the facilitators should speak or those who actually acquired some new knowledge at the round table? Let me share my impression of the day and the knowledge that we may have acquired during the day. My impression of today is splendid because I'm really productively tired. I visited several round tables to get some, albeit superficial, idea of what they talk about. So I've been running and jogging since 8:35, and I have those pictures and big brushes because I could never attend the same round table from beginning to end. So I don't have an in-depth idea of how you all worked. What I'm sharing with you is just sketches. You may find them interesting. I find them interesting. So since 8:30, I've attended breakfast done by Goldsmith. They were discussing the relationship between English and Russian law, with a special focus on the recent amendments introduced into the civil law. It was an excellent chance to wake up. Russian lawyers and English lawyers participated. Russian lawyers were praising the recent amendments, so everyone had the sense that very soon, when you have an investment transaction, they will be governed by the Russian law. Nevertheless, the English lawyers, when asked what they would advise their clients, which governing law they should choose if the asset is from Russia, they very politely responded that they should discuss it with the Russian lawyers. As for what I think about that, they did not mention that, but they briefly said that we're at the very beginning of a long way aimed at improving the image of the Russian legal system. The civil code is just a first step, which must be followed by a lot of other steps, big and small. And the first one is the judicial practice under the new legislation, or arbitration tribunals, which will have to be created in the very near future. And it is very interesting to see to what extent arbitration awards will be supported by government courts. That is what can predetermine interest in Russian law, because an amendment is not enough to say that at the end of 2015 there will be more transactions governed by the Russian law. Very exciting round table, which I personally find very interesting, not just its subject, but in terms of who was there. You know, I'm not giving you the exact names of round tables. I'm giving you the essence. That was on legislative advising. I think that was a pretty name to mask the word lobbyism, but the panelists were well-known people, impressive professionals, and the presentations were very professional. Mr. Pligin from the Federal Duma, his colleague from the Federation Council, Mr. Klishis, Alexander Shokin spoke, Deputy Minister of Justice Lyubimov. It was interesting for me to listen to them. Every time they get together, the discussion is very, how can I put it lightly? And yes, I learned something from the discussion. For example, I realize now that the law on lobbyism is not something this Duma is likely to adopt. In all likelihood, the next Duma may discuss it, which sends a message to those, a signal to those who are interested in this issue. There were some proposals to change the rules for Duma so that during the second reading, the opinion of the Legislative Council should be taken into account. That's a special council which consists of academics, practitioners, etc. There is no such requirement currently. It's up to the Duma members whether they want to take them into account or not. So they want to mandate them. Advising legislators may be profit-based. I think it's a signal to our law firms which may find such services interesting. I find it interesting too. And of course, they started trying to differentiate between advising legislators and lobbyism. Examples of lobbyism were used, lobbyism rather than advisory work in the areas like taxes and corporate law. Some of the law firms were involved in advising legislators to that, even though no names were dropped. Of course, legal certainty was brought up as a big issue. Alexander Shokin from the Union of Industrialists and Entrepreneurs quoted the Kazakh experience and suggested that we copy a law of Kazakhstan whereby advising legislators through public associations, business associations, is introduced into the law, and he suggested that we borrow that. I also
remember an informal statement by Mr. Lyubimov. We need to make sure we remove the curtains in the fields of which we have hidden lobbyists, meaning that we're sitting in a lobby and the curtains, the partitions splitting our holes from one another are kind of curious because they may be hiding some of the consultants. That's a true metaphor, but being serious about it, we have learned that the power of the anti-corruption expert evaluation of the laws is now gaining strength, and in a year and a half or so we'll have the real impact of it. And lobbying should be the lawyers' mission. That is the work the lawyers get to do. In fact, a lot of argument has preceded this, but now there seems to be no doubt about it. Now, Anatoly has left, but I would like to quote a few statements from that roundtable. Ms. Gvozdilina, a retired judge of the Supreme Arbitration Court, suggested we think harder about the administrative process, and she quoted the procedures used in tax and customs investigation proceedings, and she mentioned that there has to be a way to unify all these procedures and to tie them into the procedures that are underway when we do anti-monopoly investigation. In fact, I believe this is a very sound message. We are oftentimes very critical, specifically about the absence of clear-cut procedures in the anti-monopoly process, which may well have been achieved in other industries and be already available. Also, she referred to a recent resolution of the Supreme Arbitration Court on anticipating the appeals. She quoted the resolution whereby the Supreme Arbitration Court agreed to that the warning can be appealed against, but following a certain procedure of notification. I believe there is no way this can be done, but such is the practice of today, so we'll see what happens next. Most of us attended the outstanding address by Zorkin. I don't want to comment on this. And it's hardly possible to make a better statement than the one we heard. However, I would like to quote from his address. Here are some of the statements for you. Here is a statement on the difference between a donkey and a human being. The donkey goes around in circles, whereas a human being evolves in an helix-like way. When it touched upon Eurovision, he talked significantly about the order and mode accepted in other countries. Now, there was a lot of debate on the sanctions in a different roundtable I attended, and in fact the sanctions are widely applied today against Russia, as well as there are some counter-sanctions to respond to them. I thought it was interesting that the European sanctions in fact are not sanctions in effect, because sanctions is mainly something that is enacted based on the resolution of the Council of the Security Council of the United Nations. So it is a unilateral restrictive measure. That's the right term for sanctions against Russia. Now, lawyers, attorneys, this roundtable has just ended. I understand you've had a very active discussion. Elena is here with us, so she may wish to report on this roundtable, but I thought it was exciting listening to the way the attorneys were talking about their issues. We do have a feeling that reforming the legal profession, ensuring access to justice, are such vibrant issues these days that there is no getting away from it. Property rights. Well, I understand there are experts really specialized in this, so I won't share this with you. I missed out on the taxation-related rates roundtable, but Dmitry Kornev is with us, so he may wish to share what it was like in their session. We have a few extra minutes, I believe, we can use for that. In fact, I'm glad there aren't that many people today, because we're trying out a new mode today, so it's good we didn't have that big an audience for that.
Ну, в общем так, про вечные права не говорю, а так в целом
So
во всем остальном,
I'm not talking about rights related to property, leaving this to my colleagues, and so I think I've reported to you everything I've attended and listened in to. I believe this has been a very busy day, and in fact I'm feeling somewhat hurt, but I'm confident this was not a day lived in vain, so I'm ready for a little drink. The last thing we want to do here is abuse your attention
Не хотим злоупотреблять
and time.
вниманием, должны ли мы уложиться, так сказать, четко в график, тем не менее.
I just want to give the floor to Anna Serebrennikova for a quick contribution.
Да, спасибо большое за такой теплый.
Anna Serebrennikova, whom we love dearly. Thank you very much for this warm welcome. In fact,
Тему, которую я хочу осветить.
before I share my impressions with you, I'd say that I was really impressed with Henry Reznik's statements regarding a bias in our judicial system, a bias towards the judgment of guilt. I would subscribe to every word of it, and in fact, he's sharing the truths that have been true for more than several decades, and we still don't know how to approach this. I agree with Yelena's comments on that.
С одной стороны, это проблема
On the
государства.
one hand, it's an issue with the governments, it's an issue with building the system of investigation, the prosecutors' involvement, and the rest of it. At the same time, it's an issue with the attorneys' community that should not be trying to fit into the existing and shaped tradition, but they should be shouting out for assistance and involvement of the international organizations so that the criminal process really becomes an adversarial one, so that the filters really do get to work. I mean, the state, the government has instilled the filters, but is hardly ever using them. And I believe here we're being critical of ourselves, because our own awareness of law as we are lawyers, as we are attorneys, is what should encourage us to step against this system. So I believe we ought to get very serious about our own selves and to more seriously consider what professionally we are practicing. Now, I would like to introduce a general roundtable on the international private law. As you understand, in the plenary session yesterday, we were saying that we all feel that the international law is in crisis and the traditional international legal institutions are not working properly, so the government gets to interfere much more closely inside domestic cases, domestic issues, and also when dealing with the adjacent states. So this harms tremendously the society at large. A few words about the roundtable on the role of the government in their international relations today. The goal of this roundtable was to work out an understanding of to what extent the supranational regulating, like for instance the Eurasian Economic Union, can impact the sovereignty of the states, because we are very cautious about protecting our own sovereignty today, and we believe it's a must today. At the same time, we understand the speakers do not put at risk the sovereignty of the states, but it's just a matter of ensuring deeper integration of governmental and non-governmental international organizations, as the Russian Federation are just stepping on this long path forward. However, a wish and the intention of the states to create supranational authorities that will effectively regulate a number of relations is already visible. We are business lawyers, so we are concerned about the initiatives taken by the Anti-Monopoly Service, but we'll see what it ends up in. Besides, I had a roundtable today on establishing the borders on state sovereignty and the internet, the limitations of freedom, and there we considered some more generic issues related to regulating in international law, regulating the activities of larger corporations. So we had a representative of Microsoft. It's an American company, and nevertheless they impressed me with the case they're now considering at the American courts. Now, the servers of Microsoft are stored in Ireland, so they thought they had a right to deny the request of the government of the United States to provide the confidential personal data of the users because the legislation of the United States is not extraterritorial. So they've already lost the first round, but they hope they will get up to the Supreme Court of the United States, and there they will successfully defend their right to deny access to the users' personal data to the governmental authorities of other states, including the United States as an other state in this specific case, which to me is a true manifestation, expression of democracy in its very true and vibrant sense. The American-European regulating relations in the internet are progressing in different directions. In the United States, they're really working extensively to exchange information on a legal basis. They quote the amendment number 1 on the freedom to gather and express one's opinion. At the same time, in Europe, we see some very extensive developments of the restrictive regulations on the right to be forgotten in the internet. And the right to be forgotten today is in many activities and events considered an important one. So the operators have now a right to block the information, to delete it. Now, if Hitler had relatives and they asked you to delete all the information on Hitler from the web, would we have to do this? Well, it's an example which is a true extreme, and you can say the court will consider whether or not this has a significant implication for the society. Nevertheless, said that the trend is quite alarming. Besides, in Europe, as there is no relevant legislation, there is a practice of significant anti-monopoly regulating, whereby they place a ban on informational services. For instance, in the European states, in Germany, in Italy, in Belgium, Uber company was banned. It's a taxi service providing services online, because the lobby of the national taxi drivers, acting based on a license issued by the government, led to encouraging the anti-monopoly authority to put a ban on this kind of services. And it's interesting when the national domestic markets start to impose limitations and restrictions, even in the absence of such legislation, for the sake of and in the interest of one's own domestic national interests. In fact, anti-monopoly regulating in internet relations is an issue that is growing in significance. In Russia, we had the first case, Yandex against Google, whereby the search engines get imposed in the Android open system, and the senior lawyer of Yandex has told us about that. The overall positive conclusion we made at the roundtable was that the international cooperation in the internet is inevitable. That is, there is no way you can regulate by the national laws an environment, a medium where you have no borders. We have a good example, as one of our speakers said, of the case when international cooperation truly works, and it truly works in space and in space industry. So I believe this is the step we ought to take further in the internet and regulating internet. We ought to consider this as the new kind of space, and we ought to regulate it on a supranational level. Thank you. Internet is our new space. I was thinking 45 minutes is an awful lot of time, but apparently we are not there yet. Nevertheless, colleagues, we ought to round it up now. So, Ksenia, if you would like to share a few words about your conference. Mercosur, what's that? In fact, my contribution is going to fit in extremely nicely here. You were talking about the supranational nature of certain interventions and issues, and this is entirely shared by the issue we discussed. In fact, I not only acted as a moderator on Mercosur session, but also attended an outstanding session on BRICS, because these are the issues I'm working on. This session lasted from 9 a.m. to 6 p.m. and it was a truly international one.
Присутствовали представители Китая, Индии,
We had participants from China, South Africa, India, Brazil, lots of speakers, outstanding presentations and papers, excellent discussions. All of those people attending are there to represent and defend the interests of their own states. So it's about anti-dumping, it's about ensuring that the national enterprises are not subsidized at the cost of international enterprises are not subsidized at the cost of the national enterprises. So as not to interrupt the competition, which I really, really loved. Now moving on to my session on Mercosur. This was a conference of the states that are the participants of the Latin American market. Alexander Konovalov opened it. He noted the prospects for cooperation of Russia and the Mercosur countries, as well as the Mercosur Union as well. And he said that the representatives of the Russian business should learn more about the legal systems of the Mercosur countries. I am a moderator, so I'm focusing on the factors that encourage and aggravate the integration historically as well as currently. We had
прекрасные спикеры, министр
excellent speakers there, the Minister of Justice of the Republic of Argentina, Mr. Alac. In his address, he identified a number of goals shared by the Mercosur state. In particular, he noted the importance of contributing to democratic development, encouraging democracy. Besides,
говорил об истории и современности,
he talked about the history, the
говорил о взаимодействии
contemporary situation, the institutional structure of Mercosur, about cooperation between Russia and South America, cooperating with North Africa America as well. Besides, we had a judge from Brazil who shared her views on how the accession of Brazil into this integration-focused union has affected the Brazilian national legal system. Besides, we had an outstanding contribution from the senior research fellow of the Institute of Law under the government of the Russian Federation, who drew a parallel between the between Mercosur and the Central American unions. She identified some similarities as well as differences. Besides, the speakers had a very fruitful discussion during which they answered multiple questions, and the overall conclusion of that session
отметили следующее.
was
Дальнейшего изучения
the need for further research into Mercosur in terms of splitting the reality from what the illusions are, from what can be done, from what we would wish were done.
I'm afraid you don't have more than half a minute. I can't but very briefly read out what two very well organized facilitators wrote. Mikhail Shvedkoy described a proposal which was born as a result of legal access to cultural heritage. The problem, as it turns out, is that during exchanges among different countries, there is no regulation, no rules regulating the exchange of cultural items among the countries, and it is a good idea to create a permanent round table to develop such rules. Another round table had to do with anti-corruption tools. The facilitator, Oleg Plokoy, head of division with the presidential administration, came to the conclusion that social control mechanisms should be developed to fight corruption. They discussed liability of cooperation, etc., but that is something we can read on the forum website. Thank you all so much. Tomorrow we'll have a similar summing up session at 6 o'clock. Please come and support us, give us a hand, and share your own impressions. We may decide against inviting facilitators tomorrow. Instead, we'll ask those who participated in the most exciting and interesting roundtables. Please come and share your ideas. What do you think? Is it a good idea? Because the facilitator, I know what I'm saying because I was a facilitator. They just retell. They give you an overview of what was said. Maybe some of you instead would like to share your personal opinions. You're raising your hand. Would you like to say something? No, you can't talk without a mic. I came here by chance. I did not know that it was going to be final session, but as long as I'm still here at the end, I'd like to give you some feedback. Go ahead. Very high level of the forum. I was afraid of a lot of empty talk, which is a sin very popular with lawyers, but the 2 days have been very productive and a lot of people put their soul into what is going on. I think it is a good idea to have feedback after each discussion. If you put a piece of paper on the tables, giving people an opportunity to give their feedback, it would be great. A lot of round tables find it difficult to stay within the time limits. Mikhail Kuznetsov facilitated the round table on mergers and acquisitions. It was brilliant. I loved it in terms of the content, in terms of how he facilitated it. Is he from a law firm? Yes. You can pay them by the hour. Firms like his, some others, you don't want to pay them by the hour because for him time is money. And others just indulge in a lot of empty talk. We need more respect for time. And what is lacking is a dialogue. People do not always have a chance to ask questions. We have listened an overview of the day, which is cool, because you cannot always attend every round table. I've heard information about 4 more round tables, which I didn't have time to attend. But to give a chance to ask questions, to have a discussion, especially in the rights in RAM, property rights group, it's great. In such a group, you feel humble to ask your questions, even though the civil code is something very important. And yes, you want to improve it. You cannot leave it in peace. And yesterday, I'd like to thank the brilliant presentation, incredible presentation by Mr. Zvegintsev in the evening event, the concert, and Philharmonic concert. Hopefully tomorrow will be as good, but I would like more feedback, more dialogue at the end of the day, if not during the groups. This idea of question forms is on the surface. Thank you so much for great feedback. Well communicated to the organizers. I personally promise to communicate your comments to the organizers. I forgot to mention one more round table, which I personally attended. Ruslan, I'm afraid he worked too hard. Let's welcome him. Let's appreciate his hard work with a round of applause. It had to do with obligations and commitments. I stepped in during the most exciting proposals. There was an idea to probably introduce something new in our legislation on losses, a reasonable degree of proving the losses, where you don't have exhaustive evidence proving that the losses were incurred. The court should decide whether there is preponderance of evidence or not. If the court concludes that the evidence exceeds 50% of what could be gathered, then the court makes judgment on the damages. And number 2, the paying damages for the loss of missed opportunity. And an example was somebody very handsome was not allowed in the final round of the competition, and as a result they lost an opportunity to become world famous. And the court calculates the probability of winning in such a case, and it may well be that the court will impose damages for the lost opportunity. Yes, the day has been very busy, very productive, and once again, very,
Спасибо
very
большое, Руслан.
exciting.
Мы завершаем.
Thank you, Ruslan. That's the end of the day. Please come back tomorrow.
Служебным положением приглашаю на стол
And
объединения
now,
корпоративных
I would like to invite you to the Corporate Lawyers Round Table at the Legal Department Golden Age at 12, and then protection of business from bankruptcy, because